All right, welcome back, everybody. I'm James, co-founder, executive director at Present Pillars. Uh, Back again, another stream for Due Process for Dads. Today we'll be covering estate planning with Blair Johnson. Um, I'll bring him on in a second, but first I just wanted to remind everyone that this Saturday at 5 o'clock at the Mendel Center, Upton Grand Ballroom, we'll have the third annual Pillar Awards. Really excited about that. We also have an online auction that you can take advantage of. That is in the comments, so please check that out. You'll find a link to that auction in the comments again. Other than that, please we still need sponsorships for Shop with a Pillar. So please keep them coming in. We're doing really well. I think we're going to be we'll hit our goal for sure. But keep them coming. We want to bless as many kids as we can this holiday season. So with that, I welcome to the stage Blair Johnson. Blair, how you doing?
Hey, I'm great. Can you hear me, James?
Yes, I can.
All right. We're mixing it up. I'm doing this from home tonight. Oh, it's great. It's great.
Good. So I see we can add in. You ready to get started?
Yeah, got everything loaded up. Let's kick her off.
Anything you want to tell people before we get started? Any disclaimers? Anything like that?
No, I mean, just I'll pop on to what you were just sharing about the auction. I did submit a what would you call it? I guess it's available. A simple estate plan. We're going to be talking about estate planning. You can fill them in, I guess, on what you call it. But basically, I'm offering up a packet of what I'll be discussing tonight for bidding at the gala this weekend and the online auction. Unfortunately, I'm not going to be able to attend, but so I can explain all of what goes into a simple estate plan here tonight, and definitely support Present Pillars by putting a bid in if it's something that you are thinking about would be important for you right now.
Yes, sir. And like you said, that's definitely a great thing to take advantage of, and possibly even get it for a steal. So,
For sure.
please check out that auction and see if there's anything you would like there. So, with that, Blair, I'll let you get to it.
All right. Trying to remember how I can control this. I'll go full screen. Perfect. All right. Well, welcome everybody again to Due Process for Dads, our third of 7 episodes here tonight. We're going to be talking about estate planning. Making a will is one part of it, but there's a whole lot more ground to cover. So we'll bang it out and try to answer any questions that may come through at the end. So what is estate planning? Estate planning is the process of making arrangements for your assets and personal matters to be handled if and when you are no longer able to make decisions for yourself. So these include things like managing, and we're talking about 2 events here. We're talking about if you're incapacitated and unable to make decisions due to hospitalization, due to incarceration, due to being absent from the country or the area for an extended period of time. That's incapacitation. And then on the second side is have passed away. That also is a obviously a life event. And so we're talking about how you manage your property and do that sort of thing once you've died. So and again, like I did before, these slides are going to be available at any time. You can email me, email James, and we'll get them sent to you so you can, and this will also be available on the YouTube channel if you want to watch it again down the road. So what does estate planning include? It might include a will and a testament, last will and testament. We're going to go through each of these in more detail. It might include a power of attorney. Patient advocate designation is also known as a medical power of attorney. It's also referred to as a healthcare directive. But basically, it's a power of attorney for your medical decisions, where a traditional power of attorney is more for handling your finances, your property, and everything else other than medical. A trust, we're going to talk a little bit about trust. Trusts are super complex, and so I'll touch on them, but it's not something I can really get into a lot of detail tonight because they are labor intensive and really very fact specific. Ladybird deeds, I really want to spend some time on those. It's a really hot area right now, and we'll talk about that and what exactly that term is. And then beneficiary designations, and those would be on your life insurance policies, your retirement or investment assets. A lot of those plans will have a beneficiary that you can designate in the event you die, who will receive the assets that are in your name. Why does estate planning matter? I've taken this list from another attorney, but the list is fairly long. I think this covers a lot of good ground, so I thought I'd pluck it. Avoiding or simplifying the probate process for loved ones. That's the number one reason why clients who come to me, and I've been doing estate planning for over 10 years, is that they want to avoid the probate process for their loved ones. Talk a little bit about what probate means. Also, planning for when you can't make decisions for yourself. Who are you going to authorize to speak for you, and in what capacity, to what extent? Protecting your minor children. In wills, you're able to designate a guardian and a conservator, as well as the same for special needs dependents. Now, these are not necessarily automatic. You would have to file a guardianship or conservatorship, which is another type of probate matter separately, but you can designate in your will, this person or these persons are whom I would like to raise my children, minor children, in the event I die prematurely. Controlling the distribution of your wealth when you pass away. Where's your money going to go? To some extent, how will it be spent? Who will it be distributed to? Protecting your assets from creditors. That's probably number 2 on the list of people that come to me, is they don't want to see what they have left after they die be soaked up by people they owe money for, owe money to. So setting up an estate plan to try to minimize or eliminate the ability for creditors to come after your assets. Minimizing or eliminating taxes on your estate when you die. It's not as big of an issue as it was 10 or 12 years ago. The estate tax threshold was increased to over $10 million back in 2010. So people really aren't worried too much. There are other taxes, gift taxes, income taxes, that can be an issue, but the estate tax concern has been significantly reduced based on the threshold that was raised over a decade ago. Ensuring financial security for your loved ones. Again, kind of going back to controlling the distribution of your wealth, making sure that your loved ones are taken care of to the best of your ability when you're gone, as well as making consideration for blended families. You know, one common areas with blended families is if you marry, your spouse has a priority under the law, under intestacy laws, and then their offspring would take once he or she dies. And if you have children from a prior marriage or relationship, you don't want to leave them out inadvertently. And so, you know, just considering how you want to make sure, if you have a blended family, you're going to take care of your spouse as well as your children who may not be from that spouse. And one thing I always point out, and I'm going to drill it home tonight over and over again to my clients, is listen, not making a decision about your estate plan is making a decision. We are all going to go away sometime, and sooner sometimes than later. We just don't know. And if you have not made a decision, then you're leaving the decision up to other people, and that's a decision. So what exactly is a will? So a will is a legal document that names the people who will inherit from you, what they will inherit from you when you pass away, and whom you're going to designate to distribute your assets. Wills typically include the names and contact information for your heirs at law. Those would be your spouse, your children, sometimes parents or siblings. But you can also list devisees, who are third parties who may not have any biological relationship or legal relationship to you, including charities. So you would identify those individuals or institutions. The person or persons you want to designate to be responsible for distributing your estate. Most people think of it as an executor. In Michigan, the legal term is personal representative. So who's going to be responsible for carrying out your wishes? And as I mentioned earlier, the person or persons you would designate to serve as a guardian or conservator for your minor children when you die. They're given a priority in the event you have minor children when you pass away. Your will has said, I want so-and-so to take care of my kids. Now, if you have shared custody, or if the other parent has custodial rights, and their rights haven't been terminated to your children, they're going to be given first priority under the law. It doesn't mean that your designated guardian or conservator, and conservator is a term for people who manage the money side of things, and guardianship is everything else. Now we're going to do a little thing on guardianships and conservatorships at the very end in April. So I'm not going to spend a lot of time on that here now, but it's not an automatic. I'll just say, if there is a surviving parent, that parent is given first priority, but you still would be wise to name somebody as a guardian or conservator in the event that other parent isn't around, or you just want to have that opportunity for that guardian to step in if they're needed. You would name and identify the specific property you own and who you want to receive it. You would also, and also, as all these other documents limits the authority that your personal representative has in terms of their ability to administer your estate. So they can't engage in self-dealing. They can take as an heir or devotee in your estate. They're entitled to reasonable compensation for work performed administering your estate. And all of that is spelled out. You might also include in a will your funeral arrangements or any organ, tissue, body donation you want to make. That's also an optional form. You can always leave a handwritten or a typed list of specific items you want to leave people, and that's often for things like jewelry, family heirlooms, photos. That can just simply be attached to your will, or just written up. A will is revocable and modifiable at any time. You may have heard of the term codicil. A codicil is a legal term for an amendment to your will, but you can always revoke the will you have and write a new one at any time. To really be solid in court, if there's an issue about the authenticity of your will, the best practice is to have your will signed before a notary public and in front of two non-family members who are serving as witnesses. If you die without a will, this decision, you're making a decision without making a decision, you will be determined to have died intestate. And intestacy law is a set of laws, and we have them in Michigan, that's going to determine who receives your assets when you're gone. And it might not necessarily be your loved ones. It might not necessarily be who you want it to be. So when you die without a will and you leave behind property that needs to be administered, and the court is asked to engage in that administration, which isn't always the case, the court will look to the intestacy law, which has a series of tiers and levels of priority. So it starts with a spouse, moves to children, moves to siblings, moves to parents. And so the court just goes down that list, and each tier divides up the assets equally amongst that tier. So a good thing, again, your will may match what the intestacy law would say for somebody in your situation, but it's much better to have your wishes expressed so there's no question as to what you want to have happen with what you've accumulated when you're gone. What is a power of attorney? So a power of attorney is a legal document that gives someone authority to make decisions for you when and if you become incapacitated. And as I said before, hospitalization, absence, incarceration. It can be a durable power of attorney, which means it is effective immediately upon execution. It could be a springing power of attorney, meaning it'll only take effect in the event certain conditions happen, like maybe you are unable to, you're in a coma, or you're, something like that, undergo major surgery, something like that. So there are different degrees of a power of attorney. They typically include, again, the person you're going to designate to manage your assets. That would be your attorney in fact, or your agent. And it also would cover the aspects of your life over which you're giving that authority: managing your bank accounts, paying your bills, selling property, signing legal documents. The boilerplate form that I have includes, I think at this point, 27 or 28 different areas. Pets, access to safety deposit boxes. And you can pick and choose which ones you want to include or exclude. But it covers the gamut of anything that, an attorney, in fact, an agent would need to do for you if you cannot do it for yourself. The power of attorney, a power of attorney, is only operative while you are alive. At the moment that you pass away, it is null and void, and any property that's left behind then is governed by your will, a trust, or the intestacy law. It's also revocable and modifiable at any time. As I said, it can be limited in scope, time frame, can spring to validity upon certain conditions. You can also do one for minor children over whom you have custody. There is a limit. It's a power of attorney for minor children in Michigan is only valid for 6 months. And again, you can't do it if you share legal custody with another parent without that other parent also signing off on that. But you can always renew it. And sometimes people will do that if they're incapacitated for a short period of time, or incarcerated, I've had clients who are going to be in jail or prison for 1.5 years, 2 years, whatever, and they'll just renew their power of attorney. One step above that is having a guardianship set up, which is a court order that is not revocable without the court revoking it, whereas the power of attorney is revocable at any time by the person who executes it. Again, best practice: have it notarized, have it signed in front of 2 non-family members. As I mentioned, if you become incapacitated without a power of attorney and somebody needs to manage your affairs, that person will need to file for guardianship, possibly emergency guardianship and or a conservatorship, which manages the money side, in order to establish that legal authority to manage your affairs. Emergencies, or even still, it could take about a week, and depending on the crisis that you're in, that could be really critical. So the power of attorney can be available immediately if and when something happens to you, and again, you're still alive but incapacitated. A patient advocate designation, there's a lot of similarities. This is the medical power of attorney, so a lot of similarities to the power of attorney we just talked about. This is specific to making healthcare decisions, including the end-of-life care decisions. Again, only operative while you are alive, null and void once you've passed away. You designate your patient advocate or your medical attorney, in fact, and it could be multiple people. I don't recommend it, because anytime you have multiple like co-attorneys, in fact, co-patient advocates, if they don't agree on a course of action, then they're going to need to seek court intervention to overcome that agreement and file for guardianship or conservatorship. And so it's a lot better to name somebody, and you can always name, in both situations, as well as with the personal representative, a successor. In the event person A is not available or is unwilling, let's say you name a parent, and then that parent passes away and you don't update your document, you've named a secondary, which might be a sibling. That sibling is able to step in because you've named a successor attorney, in fact, to serve in this capacity. Again, the aspects of your healthcare decision over which you're giving authority There's a multiple list, and I think that list is about 20 right now, including authorizing medications, surgical interventions, testing, lab work, things like that. And probably most importantly for a lot of people, it's including what that end of life care decision is going to be. You know, under what circumstances you do not want to be resuscitated, those DNR orders, you know, and to what extent you may want in certain situations, medical professionals to take extraordinary measures to preserve your life. It's revocable and modifiable, and again, notary public to non-family member witnesses. If you don't do it and something is needed. Now, in a lot of cases, if you go to the hospital and you're getting ready to have surgery, most hospital staff will inquire, do you have one? If not, here's a basic form you can fill out as a catch-all, just to have something. But obviously, it's better to think about this now when you're not necessarily in a crisis than doing it in the moment. So, but that's usually available if you don't have a patient advocate or healthcare directive set up already. And just to circle back, so a simple estate plan, I'll say this at the end when I was talking earlier, simple estate plan typically includes those three we just talked about. You got a will, got a power of attorney for financial affairs, and a medical power of attorney. Those are the three components, just to really be solid in all the areas for incapacitation and end of life. What is a trust? So a trust is a legal document, it's a contract that directs how your assets will be distributed, when, how, to whom, and under what conditions when you pass away, and whom you're going to designate to direct that distribution. And for trust, that person is named the trustee or successor trustee. And similar to a will, you're going to name the people that you wish to take from your estate when you die, to designate the trustee and successor trustee responsible. For folks who set up a trust, a lot of them will set it up today, put all their stuff into a trust today, and then they are the initial trustee, and it can be a spouses serving in that capacity as well, while all of their belongings are held by a trust. And again, trusts are really extensive. I'm not going to get into a lot of detail about it. They can be revocable. They can be revocable. They can also be irrevocable, which is different than the others. And they're modifiable at any time. The major distinction between a will and a trust is that a trust allows you to really drill down and be very specific about how you want your assets to be distributed. A will does not afford the authority to a personal representative to do everything that a trustee could do. And trustees, do a lot of work depending on the size of the estate, depending on the number of people who are going to take from the estate and over what length of time. And so these can get pretty costly. I'm going to talk about costs at the end. One other advantage into allowing you to be extremely specific and detailed about your post-life plan is that it's a lot harder to contest a trust in probate court than it is a will. It's not easy. If you can check your boxes and make sure that the notary and the witnesses have been signed, then your will should hold up. But a trust is really, really solid and very difficult to pierce or modify once you have passed on in probate court. It does better protect your assets from creditors than a will, and it has a much better job of minimizing those taxes for income, gift, and estate tax purposes. Labor deeds. All right, so I love labor deeds. I got to tell you guys, I wrote an article, maybe it was like 8 or 9 months ago I write for a local publication here, Sunset Coast Media, and it's a neighborhood magazine, and I write an article every couple of months about all of these kinds of topics. I did one on a labor deed, and I did a deep dive, and man, it only started in the 90s in Florida, and the labor deed is only available right now in 6 states in the United States. Michigan passed laws in 2014 that allowed people to do this, and it is a game changer. So a ladybird deed is a legal document that transfers ownership of real property that you still own when you die to the next person. It could be who you've named in your will. You do the deed, it's the same thing, but the results are entirely different. I'll explain why that is. The legal term for it is that you have done a life estate for your real property. This only applies to real property. It operates similarly to your beneficiary designations on life insurance policies and investments. So those are known as transfer on death designations. And what that means is that at the moment you pass away, the property that you own that has a beneficiary designation is no longer yours. The reason why that matters is that because it's no longer yours and it becomes the beneficiary's immediately, is that it never enters or can be entered into your deceased estate, meaning that property is not subject to a future probate court action. I mean, I guess in a rare case, you could try to challenge it collaterally, but what you've done is you've signed a contract of sorts saying, this is going to go to this person. A will is just a testimonial of what you want to have happen with your stuff. And it will only have legal effect once it's been probated by a court. That's not the case for beneficiary designations and for ladybird deeds. So the ladybird deed, the way it works is that, and it can be with spouses or any number of people who own real property together. It could be one, multiple. But what they do is basically they gift the property to themselves. So you sign a deed that says I, Blair Johnson, grantor, am granting to Blair Johnson a gift of this property. It's called an inter vivos, Latin term, transfer. In the event I still own that property when I die, the property will be given to 1, 2, 3, 4, whoever, in percentages, in amounts, whatever you want. Number one, doing it that way, you still have all the rights that you have today to your home, whatever your real property is. You're not giving anything up. So you could still, by doing a ladybird deed, you could still sell the home, you can still mortgage it, you can rent it, you can lease it, you can improve it, you can levy it, all of that stuff. And you don't have to seek permission from the people you're going to leave it to, because their interest is a future interest that will not take effect until you die. If you sell the home, and there's no limits on your ability to sell the home, then the ladybird deed and that tail on it for the survivors is null and void. You buy another property, probably should put a ladybird deed on that property, but you don't have to get permission from anybody. You would sell it just like you would sell it today without a ladybird deed. And all the future owners that you've listed on your ladybird deed or life estate have to do is record your certified death certificate with the Register of Deeds. That's it. And I'll talk about this at the end, if you don't do that and you die with real property, you're the only way that whoever you want to take, whoever you want to have your real estate, for them to get it, is if they file in probate court. So the cost savings on this is incredible. It avoids, the biggest thing is that a lot of people before 2014 were doing trusts because they had real property, and there was no way to avoid the probate process with real property. So they had to put it into a trust to keep from their survivors from having to go to court. The ladybird deed satisfies that. So I have begun to really push this as a more unbundled approach in setting up an estate plan. And so anytime somebody comes to me and we talk about a simple estate plan, oh, by the way, do you own your home? Do you want to do a deed so that your loved ones don't have to go to probate court to take possession? And again, you're not giving it to them today. You still, which is important because it's not subject to any kind of Medicaid look back. Medicaid can come after your assets if you end up going into a nursing home up to 5 years prior to going into that nursing home. And so nothing changes on the ground. You just essentially added beneficiaries to your real estate. It's amazing. I said at the bottom here, the only way to get it outside of a deed and or having a ladybird deed and or having it in a trust is for your loved ones to file a deceased estate matter in probate court. What are beneficiary designations? You see them on your life insurance policies, your retirement assets and investments. There are even now banks that are including beneficiary designations for traditional savings and checkings accounts, which, like I said earlier, they're transfer on death provisions, meaning that the moment that you pass away, all that person has to do is provide a copy of your death certificate when they get it. It takes a few weeks, but it's their property. And therefore, like the ladybird deed, creditors can't come in to get a piece of the pie, because the only way they could really get in if they haven't attached a lien, like say on your home, is if somebody files in probate court and then has to publish and notify potential creditors, this person died, there's money in this estate. If you have a claim, bring it forward. If there's no case to be filed, there's no forum for a claim to be brought in. It's brilliant. So the trick is with beneficiary designations, you got to make sure that they stay current, make sure they match with your current plan, because beneficiary designations like ladybird deeds will override whatever you may indicate to the contrary in your will. For example, if your intent in your will is that you want to leave the balance of your retirement to your kids, but your 401k beneficiary designation has your former spouse, your ex, well then your former spouse is going to take that 401k over your kids, because your will only governs property that you own when you die. And this asset here is actually the property of the beneficiary at the moment of your death. So, really making sure, and I'm going to talk about life events here in a little bit, those things will override whatever you include in your will, because they are contractual, and they have a legal standing that your will does not yet have until it's been probated. Best practice is to talk with a financial advisor about your policies and investments and make sure you got the beneficiary designation set up exactly right. When should I make or revise my estate plan? Like now is a good time. If you don't have a will, a power of attorney, your own real property without a life estate, a ladybird deed, you're leaving it up to other people to decide how your affairs are going to be administered when something happens to you, right? Not making a decision is making a decision. So put it in place now and rest easy. I mean, a lot of people, come to me, and they come to me because something bad happened to somebody that they know. They went through some horrible experience in probate court, or they got left out because of something inadvertent, and usually an inadvertent oversight, mistake. We don't know when we're going to go, and so we don't do anything about it. And then something bad happens, and people come to me and they say, I don't want to have that happen to my kids or my spouse or my family. So it's really important as well to revisit your estate plan anytime that you experience a major life event. Just check under the hood and see how it's going. You're going to get married or get divorced, make sure your plan is in alignment with what your new situation is. If you have a new child, if you lose a child, if you lose a spouse, again, some of these people may be serving in a fiduciary capacity, which is the term for having that legal authority to do something with your estate and your affairs. And so if that person is gone, you want to make sure you have a successor identified, as well as if they're gone and they're not there to take from your estate, what are you going to do with what their share is left? If you have a serious health event, if you lose employment, more at retirement, retirement is probably more significant on that front. And again, incarceration or imprisonment, more to manage things while you're going to be out of pocket for a while. At a minimum, I recommend to my clients that we review their estate plan every 5 years. Just again, check and make sure it's still there, because people generally will forget what they did or think they did something and then they didn't in fact do it. Your estate plan is going to dictate the decision of how your affairs and assets are going to be administered in your absence. If circumstances change but your plan doesn't, then the plan controls. So again, great idea to set it up, but also make sure that you are checking it so that it stays current with the circumstances in your life as they are today, or relatively approximate to today. How long does it take? So a simple estate plan, typically comprised of those first three documents I talked about, it only takes about 2 to 4 hours for me as my time to draft it up, do an interview, figure out what do you want, what are your concerns, who do you trust to make these decisions. These people who serve in these fiduciary capacities don't have to be blood relatives. They can be friends, they could be neighbors, it could be, if you want somebody that you really trust who manages finances and they're willing to do it, and you trust them to manage your money and take care of your property, you can pick that person. This is your life, and the law allows for that. So it can be, if we need to, we can bang it out in a day. But typically, for my clients, it'll take a couple of weeks. I draft everything up, they'll look at it, make sure everything is right, and then we come in and we do the formal signing with everybody around the table to witness it. A trust is way more comprehensive, can take 10 to 20 hours or even longer to set up, several more hours to fully fund. I'll talk about that in a second. And this can be scattered over several weeks or 2 to 4 months. Now, funding a trust is the process of retitling your assets and your beneficiary designations to put what you own into the trust. You don't want to spend the money and time setting up a trust and then not put your stuff in it, because anything that's not in the trust that is titled is going to have to be probated. So you've done all this work, and usually what ends up happening is you sell a home, you buy a new home, you forget to put the new home in the trust that you set up when you had the first home, and now that new home is outside of the trust and will have to be probated to be brought back in and administered. Ladybird deeds and beneficiary designations, it's really, a minimal time, 1 to 2 hours, in a day draft. I mean, just really for ladybird deed, I just need the deed that's there now, get the language, the property description, draw it up. Now, ladybird deeds, like any other deeds, quit claims, warranty deeds, these have to be recorded with the Register of Deeds to actually be in the chain of title, and that can take about a week. But the actual drafting and signing is very, very short. It's a 1, maybe 2-page document. So how much is this going to cost me? Lawyers are a great idea, please. I mean, I'll tell about it's my lawyer tips 101. So I'm factoring in some attorney fee costs here, but a simple estate plan typically runs about $1,000 for a single individual. Most of that money is spent on attorney fees to consult and draft and execute the plan. A trust can run, a couple of grand and up to maybe 10,000 or more, depending on the extent of your estate and whether your attorney is going to perform the tasks of funding your trust. If there may be more deeds that need to be drafted to awarded from you as an individual to you as a trustee of your trust, and things like that. So that range is pretty broad. A ladybird deed, $250, $300, $400, $500, all on attorney fees. There's a $35 recording fee. But the cost of probate, and I'll share this horror story at the end here. I mean, it's several $1,000s. If you hire a lawyer, if you do it on your own, you may make mistakes. It may drag on. It can take, it's a minimum 6 months. It can take up to a year or longer. You do a ladybird deed, you knock it out in a day, you record it, and then the only thing your loved one has to do when you die is record your death certificate. and they have the property. So the money up front versus the money on the back end, the no hassle on the front versus the significant hassle on the back end, Lady Bird deeds are just a game changer for a lot of folks. So in addition to those additional costs for recording certain documents, you may have a notary fee. You may have a deed lookup fee. If you don't have your deed, it's available at the Register of Deeds. It's available. A lot of these registers have online access. You can pull it offline, and then copies and postage. But the bulk of it is spent on, attorney fees, setting this stuff up. So how much might it cost me if I didn't make a plan? Yeah. So going to probate is a term that probably everybody watching tonight or watches this later has heard in some fashion. I don't know how many people really know what it is, but they just know it's a bad thing. I know I want to avoid it, but maybe you don't necessarily know why. What does it mean if I got to go to probate? So probate court is a division of the court system that intervenes to protect the rights and assets of vulnerable individuals on a very general, broad level. Probate court includes administering the estate of the deceased. If you have a will, you don't have a will. That's what we're talking about tonight. They also may be asked to or required to supervise the administration of some trusts. So not necessarily modify or challenge the trust, but oversee that the trust and your assets are being administered in accordance with your trust. And that is also what the court does with a will in a deceased estate case, is supervise. It can also be unsupervised. Probate was a little bit cheaper. Probate court also includes guardianships and conservatorships, talking about that in April, commitment and supervision of the mentally ill, juvenile delinquency, and neglect and abuse of minor children. The probate process for administering estates can take a few months at minimum, like I said, 6 months, typically, if there's real estate involved, depending on the complexity of the case. And the expenses involved can include filing fees, inventory fees, final tax preparation fees, attorney fees, publication fees, deposition and transcript fees. That's if it's a contested, a will contest or a contested probate matter, all of which may total several thousands of dollars. And as I said earlier, when you have to probate, and it's not you, you're gone, but when your loved ones have to probate your estate, your deceased estate, it is opening up what you have accumulated to creditors. It could be lenders, credit card companies, anybody who has or thinks they have a viable claim on assets or money that you own. If there is no probate case that is opened, then there's no forum or venue for them to file a claim. Now, creditors can actually also petition to open a deceased estate, but if there's nothing in your estate, and if most of it has been left to people, and I'm talking about things that are titled, the stuff in your home, the clothing, family heirlooms, they're not going after that stuff, and a probate court really doesn't dig in too deep with that. But if a probate case has to be filed, it opens it up to creditors. Probating an estate can be extremely contentious, and it can really rip families apart. I've had it happen in my family, not my close family, but I've seen brother and sister, claw over what their deceased parent left behind to them, or if they didn't make a will, that Dad loved me more. Dad wanted me to. He told me he wanted me to have the truck. It just can, and again, making a will, making an estate plan is not going to necessarily eliminate all that. But, these are, a will is a testimonial document that says, these are my wishes. This is what I wish to have happen to my things when I'm gone. And it's verified because I signed it in front of a notary and two people who are not members of my family, right? That's that idea. Raise the level of legitimacy so that also hopefully lowers the tension amongst family members that you leave behind. Dying intestate creates more harm and expense because nobody knows what you really wanted. I mean, they have theories, they're speculative, right? You know, she told me this over Christmas 2 years ago. I mean, in 10 years, I've seen just about all of it, but I'm sure I'll see new things, right? About things that are done, things that are said, or things that were promised and then not followed through. But remember, the ones who are paying the price are the ones that you leave behind. It's not you. You know, so again, think about what you want your children, your heirs, your devisees, you know, that it's all taken care of so that they can mourn you and not be stressing over your longings. And I apologize. I'm home. My children are home now. So if you can hear them, I apologize. So hot tips from an estate planning lawyer. Number one, again, remember, not making a plan is making a plan. Don't leave it up to other people or the law, the intestacy law, to decide what's going to happen. I guess when I say other people, I include the judge. You know, most people seem to realize the importance of having an estate plan based on the bad experience of someone they know who didn't have an estate plan. Beware of do-it-yourself or online self-help tools like LegalZoom. Not just, there's other. I mean, there's a whole plethora, but LegalZoom really kind of carved the way for a lot of just, you know, fill in the blank stuff. And I see those things come through, but they're not always Michigan specific. Michigan's not super difficult and technical, but every state's laws are a little bit different. And they may not offer enough information and advice on how to draft a plan that is specifically tailored to your needs and wants. Will it be cheaper? Maybe. Well, again, probably it'll be cheaper than hiring a lawyer. But is it going to guarantee that it's going to check all the boxes? And again, you won't know. You'll be gone. You thought it was going to do this, and then it ends up doing this. You know, but this isn't something, you know. And again, I think they typically cost like $250, $300-$400 for a document. So does it rival an attorney? Not seriously, but you know, talk with an attorney is really the best thing to do. We never know when our time is gonna come. And don't wait. Do, you know, just, even if you're in good health and everything, I mean, things happen. Most people go to probate because a parent or relative died owning real estate. That's the number one reason. So I'll tell you about this case I'm working on right now. It's really unfortunate. You know, there were a few kids behind. The father left behind a home and had it written up in his will. Didn't have a ladybird deed. There isn't anything else. That's all it was. It was a home and a will. All the children are in agreement. We wanted to go to this one child, which is his wish. But because he left without he left this world owning real estate, we had to file informal probate for the court to, you know, administer the will, and that process has run them now over $4,000. It started I think we started in July, and we hope to be completed in February. It's long. I've had to file 8 different things with the court. I have to send out copies of everything to all of the heirs, and all of this could have been avoided had, you know, their father known that he could have signed a ladybird deed. It would have just been a couple $100 a week, done. He dies, record the death certificate, home is yours. And so, and this stuff, and again, most people, again, because it's only been around for 10 years, ladybird deeds, you wouldn't necessarily know. You know, if you talked to a lawyer 20 years ago and you set up your plan, you wouldn't know that there's this there's this new device out there that, can keep that home from going into probate. And again, if you leave property in a will,
It'll be bath time in 10 minutes.
oh my gosh. Okay, we have Alexa set up. I'm so sorry. Up here. So if you leave property in a will, it says, I want my home to go to my kids. It's still got to go to probate. And I think a lot of people don't understand that. It's clearly expressed what your desire is. Should be no doubt, right? That this is what you want to do, but they have to go to court. They have to file a case, open up the door for potential creditors, spend a lot of time and money waiting, because it's got to be, it's either got to be in a trust or you got to have a ladybird deed. Otherwise, it's a guarantee if they want to take possession in accordance with your wishes, they have to file for probate. Remember, when you die, your loved ones are going to be grieving. Dealing with probate, it steals the time and energy that they need and could have to spend on remembering you. It sucks. It really sucks to have to pivot. I haven't gone through this personally, but I've seen it. I've seen it, the grief and the hardship, and people that I've worked with who, this just becomes something that the limited energy they have is going to take up, right? Especially if it's a parent, and even if it's a tragic incident. Now you got to pivot and you got to do all this stuff in an administrative capacity, and that's time away from remembering you. It's stress and an already stressful situation. Again, you probably don't need a trust unless you have a really large estate or blended families or special needs children. I just don't do very many trusts. I'm available and I'll do them, but since Ladybird Deeds came along, I'm really looking at that angle. Now, the benefit of a trust too is that everything is dumped in there, right? It's all collected in one pot, versus what I'm describing, is an a la carte sort of unbundled approach. But that unbundled approach is quite nimble. It allows you to do things a little easier than this hulking mass of a trust. And it doesn't require the oversight and attention to administer it, but it's also not as detailed if you don't have a trust. Beware adding other people's names to your bank accounts as a means to allow them easier access to your finances. I see it a lot with older clients, older family members, where they put their, a son or daughter's name on the bank account because what if something happens and they need them to go and pay their bills? When you do that, you've mixed it all up such that that other person is a co-owner of that account. And whether that money was your money that you brought in, the bank doesn't know it, the law doesn't know it. It's all mixed together because the two of you own that account together. You pass away, then that money is left to the person who's the surviving co-owner. And similarly, if they're the ones who take it, it's their property. A deceased estate won't apply to that because you died, the bank got your death certificate, it goes to this person here. And if your intention was, I wanted to leave what I left in that account equally to my children, it will be up to that surviving child whether or not he or she is going to follow your wishes. But they don't have to because it's actually their property. So you got to weigh that convenient. Now, in a lot of more and more, and again, this is sort of the development of this institutions learning from each other. I'm hearing of more and more banks that are allowing that have, I don't know what it's called, but where you can add that family member to have access without ownership. And they're not a beneficiary either. They're just there in the event you're incapacitated or unavailable, but they don't own the stuff that's in that account. And therefore, if you die, they don't get that money over everybody else who might get that money. They're just one of the group who might be entitled to it. And I'm sorry, the bottom of this slide here cut off. Wrapping up here. So things we didn't cover, full scope of trust, there's a whole lot. So we didn't talk about that. The full scope of tax implications. There's a lot of ground to cover there too. I'm not a tax lawyer, but I know enough to be dangerous. Medicaid planning, that's a whole big area around protecting your assets from Medicaid capture if you go into a nursing home, will contest, any of the litigation side of things. So, if there's a fight about what your will says, if there's a fight about the intestacy law being applied to your situation, if there's a fight about your trust, didn't talk about that, and administration. So what does the personal representative have to do to administer your will? What does the trustee have to do to administer your trust? That also is quite extensive. We didn't cover that topic tonight. So that brings me to the end of tonight's session. And usually James jumps in or sends me a message if somebody has asked any questions from the internet world.
I am not seeing any questions. If anyone has any questions, now would be a great time. I see Ashley Hines said that great information. Thank you. Thank you for your comment. If
Thanks,
anyone
Ashley.
has any questions, like you say, now's the time. If not, please feel free to email or call or send your questions anyway. And myself or Blair will get back to you with the answer. The answer won't come from me, just to be clear. I'm not a lawyer.
He's a messenger. And just as a reminder, so we got some sessions coming up. Now we're going to take December off because we all just need a little rest. Just let's just celebrate and adapt to 4:30 darkness. We'll come back in January and we're going to hit 3 sessions in a row about family law related matters. We got custody and parenting time in January. We've got child support in February, paternity in March, and then we're going to wrap it up in probate land again with guardianships in April. And we may go on after that too. I don't know. There's a lot of things Blair didn't cover that could be raw material for future sessions. So, Ashley, great questions. I see this. Is there a deadline for creditors to reply during probate? 4 months. So you have to publish. You have to publish in the local newspaper still, which is kind of funny to me, but you got to publish in the Herald Palladium here that so-and-so has died. There's a form you fill out. It's sent to the HP. They put it in there. They notify the court it's out. And then you have to allow 4 months from the date of that publication for creditors to respond. They either notify the court, they notify the personal representative, and then after that 4-month period has expired, you deal with the creditors who have come in, or if they haven't come in, you lock them out and you move forward, and they will be barred from seeking any relief from that deceased person's estate. And I should also say this, because this also comes up. If you're a relative, if let's say your parent, if you're an heir and your parent dies, or you're an heir under an estate, you're not personally liable for their debts, right? So I get some folks who are concerned, like especially if they have a parent living with them and the mail's coming, they got the credit card bills that are still coming. Do I need to pay this? No, you don't, because that person is no longer around. And if they really want their money that bad, and it's worth their time, which is quite a bit of money if it's going to be worth their time to file, they could file a deceased estate action. But personal representative, executors, attorneys, in fact, are not personally liable for the debts of the person that for whom they're managing their affairs. Good.
Well,
thanks for the question.
Great question, Ashley. Great answer, Blair. Does anyone else have any questions for Blair? Please drop them in the chat. We got a minute.
Yeah, if we don't cut, we're going to cut at 7. It's going to be bath time, according to Alexa.
That's what she said.
If you missed, that's what she said, and it'll come up again. I get these on my watch at work, by the way. It's kind of a running joke with my wife.
No, that was pretty funny. Yeah, but any closing statements from you?
No, man, I love doing this, James. This has been great. I don't know, I hope this has been helpful, for folks who've attended. And I was checking on your YouTube channel that it's gotten a few views, post
Yep.
And they're not all me going back to look at myself. So I think there are other people that have been viewing it. But I want this information to be out there for people so they don't have to be afraid, so they don't make decisions based on fear or misinformation. I just love doing this, and I'm so glad because you got a killer setup, and it's bath time.
It's bath time.
And yeah, right. It's been really cool. So I'm looking forward to continuing on in 2025, man. Thanks for the opportunity.
The feel is definitely mutual. So also, again, we just want to remind everyone the Pillar Awards is Saturday. We do have limited capacity for in-person ticket purchases, but very limited capacity. So if you want to get there and you haven't purchased a ticket, please be there first. Also, the auction is live now. You can find a link to it in the comments. That will close out Saturday night as well. And we're still looking for sponsors for Shop with the Pillar. So keep them coming. We're doing great. And that's all we got for tonight. So thanks again to Blair, and we'll see you later.
Thanks, James. You all have a great Thanksgiving.